And just to let you know how this goes, this looks like a really orderly group, not too noisy and all that sort of stuff, but this is a regular committee hearing. And we have, the Senate Health and Welfare Committee this year and a couple of years ago took testimony from some of you here in the room about how you were personally affected and your families were affected by wind turbines in your neighborhood. So we've got that. This is an investigation and an inquiry to what happens when people complain that they feel that something about their lives is being damaged by the production of wind energy. We're going to ask the people who advise about the policies, the people who oversee the policies, the people who look into noise complaints and possible infractions of CPGs. Annette Smith is going to speak at the end, which is usually the premier position in any kind of testimony. But what I've asked her to do, she's on gate right now, is to listen to what people say about how the process works or doesn't work, and that sort of thing. And at the end, her comments will be about the process, her observations about the process. It won't be about wind, it won't be about noise, it won't be about anything else, just the process. I think we could do that in a couple of hours. And what I would ask, and I think I have a feeling I don't need to ask this, but please don't clap, please don't pull our heads, certainly no spitting or anything like that. So, it's really for us to listen to the witnesses. We'll only be asking clarifying questions, and that sort of thing. But you're our guests, you're invited to listen. Thank you very much. And then we're going to adjourn to our room. We'll talk a little bit about this, but we have some other business which you won't find quite so fascinating, I think. Thank you. So our first witness this morning is June Tierney, General Counsel for the Public Service Board. And on our website, for all of you here, are a list of questions that we sent to all of our witnesses. Some are particularly for some parts, and some are in general for all of our witnesses today. Good morning, thank you for coming. Our thinking is we're not going to go through the questions. You've had them for a few days, and we'll just, we will only ask you to clarify, if possible. And I'd ask you to make sure you use these mics so the people behind you can hear us.
Testing.
Okay, all right.
Thank
you. Good morning. Why don't we introduce ourselves, just so that everybody in the room knows who we are.
Senator Eric Lee from Washington County.
Senator Jenny Lyons from Chittenden County.
Claire Eyre, Addison County.
And Brian Collmore from Rutland County.
All right, good morning and welcome. Thank you for being here.
Thank you very much, Madam Chair. I'm Sarah Hoffman, and I'm one of the board members on the Public Service Board.
I forgot that. Wow. Yeah.
We had Ms. Tierney scheduled to come over here today, and the more we talked about it, we thought, and she's going to do primarily most of the talking, but we thought this was important, and if you had something you wanted to hear from the board, and of course I'll be chiming in, I can't help myself, that you want from a board perspective. I'm here to help with that in any way we can. And just wanted to say, we know this is important. We know we're talking about individuals. A lot of them concerned about their health, and we take that very seriously. We're trying to balance a lot of different interests, but are very pleased to be over here today talking with you. I'm going to turn it over to June, and she'll introduce herself, and we'll start working on the questions.
And did you send anything to us by email? I didn't see anything when I looked earlier this morning. We did ask for it in writing.
Indeed, I did regret that we weren't able to send it to you electronically. I've come with paper copies, and I'm happy to send them electronically when I get back to my office.
Okay, well, why don't we take paper copies for now, and we can leave them here. It depends on what we do with the notes. Thank you. Good morning.
Good morning. It's my deep pleasure and honor to be here today, both to meet fellow Vermonters on a topic that is very important to them and to be responsive to the committee. Since you don't want to go through the questions, but prefer to take clarification, please let me know how I can help you.
No, it's not that we don't want to go through the questions. We are not going to ask the question and have you respond and then ask another one. Just go through it on our own. Thank you.
Very good. In that case, if I may just locate my notes, I'll be glad to start. In going over the questions, what I tried to do was interpret them in a way that was tailored to the board. Not all the questions seem to be necessarily things directed at the board, so to the extent that I've erred, please let me know. In the first instance, where you asked what procedures in place for a person affected by wind generators, C, meaning the complainant. If the process varies for different projects, please explain the differences. What I've tried to do in response to the question of written policies is provide you with links to the board's policies. I also have paper copies of those things that the links take you to. One of them is a general description of the board's and the department's complaint process. Another is a specific page that outlines the sound monitoring and complaint procedures for wind generation projects. This is on our website. And then another is an excerpt from the board's procedural rules that spell out how you initiate a complaint and requesting relief from the board, and then also filing consumer complaints. The consumer complaint mechanism is available when the wind generation project is owned by a utility as opposed to a merchant generator. So GMP, for instance, owns one of the wind generation projects. Somebody who is a customer of GMP or who is a service from GMP could avail themselves of that consumer complaint mechanism.
I'm having a little bit of a hard time understanding what he's saying. Yeah.
Glad to do that. Is this better?
I think so. You're going to have to speak up more. I'm sorry. Yeah? Not just me.
Glad to do that, Madam Chairwoman. This has been a lifelong problem of mine. Either I'm too soft or I have a command voice, and I continue to struggle to find something in between.
Well, I think it's just fine right now.
Excellent. Was there anything about what I just said that you'd like me to repeat?
I don't think so. But let me ask you that. You said that in these links are the answers to all these questions. Is that right?
I believe that is correct, yes. When I say links, I mean to the first question, does your company have a written policy for public complaints?
Okay.
Going to the next question, do you have separate procedures for sound as opposed to other types of complaints? The board itself does not have a separate procedure. However, each wind generation company is under an obligation to have a sound monitoring protocol and a complaint protocol. And that is different from other types of projects the board regulates, such as transmission lines or weight cases and things of that nature. Does your company have a single telephone number or email and person to respond within a specific time frame? Yes, I would say adapted to the board, that would be the clerk of the board. Who does the public contact? The clerk of the board. Who answers the phone and email? That would be the clerk of the board with assistance of the clerk's staff. Is it recorded where and by whom? Electronic mail contacts obviously are recorded because they come to you electronically in writing. Telephone contacts are not recorded in that manner. The board does not maintain a log of telephone contacts. It is common for a message to be taken the way that happens at an office, and those messages perhaps would be reviewed as a record, but they're the type of temporary.
You're
Yes,
fading.
I'm fading. Okay. Fair enough. And I'm probably also getting into the weeds now. I'd ask you to let me know.
No, I think
too much
the beats
detail.
are where people are when they call at midnight on Friday and want to know
Fair
why
enough.
someone didn't come back in 5 minutes.
Gotcha. What response can be expected to the situation? The response varies depending on the nature of the communication we receive from the public. A written comment about sound from a wind project will be placed in the public comment file, particularly if the person who's contacted us has characterized the comment that way. A comment like that might be something like, I really like renewable energy projects that are wind generated. I really don't like wind projects that are generated. The I really don't like the project comment has, characteristics of a complaint, but they would not be identified as a complaint in the legal sense as somebody who's looking for relief for a particular problem. So that's why they would go into the public comment file. It can happen that if you get enough of those kinds of complaints from people, that at some point the board might say, we've gotten quite a few complaints from very many different people, and perhaps there ought to be a query to the department whether they're investigating this, or there might be an initiative by the board to open an investigation. For instance, at least in part, when the board opened its sound investigation, it was motivated to do so by the sense that there had been public comments about wind projects and the need, or other generation projects like transformers, where there has perhaps been a need identified to examine whether you meet sound standards. Another possible disposition of when you get a written complaint that is of a legal nature, meaning I am somebody who has been hurt, I believe, and I need this to stop, or I need limits to be imposed or something like that. When it comes to us that way with a certain level of factual support, affidavits for instance, that might prompt the board then to say, we need to consider opening an investigation into this particular complaint. I don't recall the board doing such an investigation without first consulting with the department, with the wind project owner, to find out what their responses are to that kind of complaint before it's going. In a nutshell, the possible responses to receiving a complaint that comes to us in the legal sense is to open an investigation into it, to set a hearing, to issue an order to show cause why a penalty shouldn't be imposed, or a term imposed on the operator. It might be to send a letter explaining what steps the board intends to take, and it could also be a letter that explains where the board is not taking further action. And I have copies of those kinds of letters for you today, just as I have copies of board orders opening investigations into sound complaints. You've asked who has the burden of proof. This too varies depending on the nature of the remedy that's being sought. For instance, if a well-founded complaint, meaning one that's supported by the affidavit, for instance, comes to the board that alleges a CPG violation, the burden of proof will be on the CPG holder to demonstrate compliance or to otherwise show cause why the board should not assess a penalty or other available relief. By comparison, if an injunction is requested, meaning somebody is asking that the operator stop the project, or if reconsideration of a board order is sought, as in, board, you ordered that this project operate within a certain level of sound, but we really think that needs to change, that's asking for reconsideration of the board's order. That would be governed by the rules of civil procedure in board cases, which will the burden of proof rests with the individual who is asking to reopen the matter. I should point out to you that it's a very extraordinary thing to happen in legal proceedings, simply because you're balancing the grounds that are asserted against the finality interest. To my knowledge, in board proceedings, that has not happened to date. Does the complainant, I feel compelled to tell the committee that I don't like the word complainant, but sometimes we're limited by English. The person who is expressing their concern is what is the more formulaic way I would say it, but I think all agrees.
The way we put it, C is the person affected by wind generators.
And so I can refer to
Good,
this.
right every time.
I think you probably have the same concern I have.
Okay.
Yes, Sam.
Has a specific legal.
No, I'm telling you, I feel compelled to tell you that. I always stumble when I use that word because I don't like calling somebody a complainant necessarily.
So for the benefit of people who haven't looked at these questions, we call the person who feels that they're affected by wind generators is just C, or whatever. And that's how we'll refer to those people.
So I will now refer to C.
Yeah, just so you know.
The question is, does C know what is going on? And my answer would be yes, if C is a party to the complaint proceeding or has asked to be included on what we call the service list for the proceeding. When we keep contact with the clerk of the office and you said, I'm really interested in this matter, the clerk will say to you, all right, I'll put you on the service list, and when we issue things, we'll send you a copy of that. Alternatively, C is also welcome to contact the public service clerk and to inquire about the status of the complaint to the extent that she's able to, or she is. is able to give, she, the clerk, is able to give an answer, the clerk will do so. Does C know when resolution of closure is achieved? Yes. Who is responsible to make all of the above happen? That would be the public service board. That's it.
Can you just elaborate on the yes? How do they know that it's reached closure?
Fair enough. Depending on what closure is reached, they will either get an order if there was an investigation or proceeding of some kind. They will get a letter from the board, or I use board in the large sense here, meaning the letter may be signed by the clerk, the letter may be signed by me in some instances, explaining what has happened. Who pays for the system around this? That was a difficult question for me to answer any time I've had. I mean, loosely speaking, the Public Service Board is funded through a special fund. That special fund derives its funds from utility gross receipt taxes, and in turn the utilities recover the cost of that fee from their ratepayers and rates. What does it cost to implement the complaint system? I honestly can't tell you. I don't have a way of breaking out the Public Service Board's budget to tell you how that complaint system is administered or paid for. What is your company timeline for completing work on any complaints? The Public Service Board certainly aims to complete such cases as promptly as possible without compromising the fairness or the thoroughness of the process and the inquiries and deliberations needed to secure a just and reasonable outcome. I know that's a mouthful, but this is something that I can't overemphasize. Public Service Board cases deal with complex matters, technology, science, finance. These things don't lend themselves to simple resolution. And so while a person may have an individual concern, that concern is always woven into a larger tapestry, and resolving that concern requires tugging on many different strands in the tapestry. The board has to make sure, that everybody's interest is safeguarded in trying to reach that resolution. And that takes time, and it competes with other things that we are tasked with doing as well. How is the remedy to complaints designed, documented, and implemented?
Center lines is going to yell at everybody in the hall, and then she'll be back in 5 minutes.
And perhaps I could try speaking up too.
That would be excellent.
Yes. In general, the board designs remedies for complaints by applying the relevant statutory criteria and calculating penalties that are set forth in Title 3030 of 30 VSA. I garbled with that. Title 30, Section 30. In specific Section 248 cases where wind generation facilities have been granted a certificate of public good, the board has included in that certificate a remedy requirement for sound level exceedances as a condition of approval. By law, the board is also authorized to issue injunctions provided the legal requirements for this remedy have been met. And finally, under certain limited circumstances, the board is able to reconsider its decisions to grant a CPG for Section 248 generation facilities, and that would be pursuant to Rule 60B of the Rules of Civil Procedure. Remedies are documented and implemented through board orders as well as in compliance filings that are ordered by the board. Remedies are also documented and implemented through a settlement, often referred to as a memorandum of understanding, that is negotiated among stakeholder agencies such as the Department, the Industry and Natural Resources, and the CPG holder. And I need to bring my voice up again. By whom and what time frame, who oversees compliance? The Public Service Board, again, it aims to do these things as promptly as possible, and the Public Service Board itself oversees compliance through the actions of its staff and the clerk, and through its interactions with the Department of Public Service and the CPG holder. How does the C and the public know what's happening? Again, if you're a party to the proceeding, you're going to get a copy of whatever communication order the board issues in the matter. And if you've asked to be included on the service list, you'll get those copies as well. You're also welcome to contact the clerk to inquire on the status, and in some instances, the Public Service Board website will have information as well, the published orders. I will tell you candidly, the website is not everything it could be, and we are actively transitioning into an electronic case management system that should make this much more easy for the public to use, and with that, make more documents available. But the bottom line is, to the extent that a document is available to the public pursuant to the Records Act, if an individual contacts the Public Service Board, every effort will be made under law to get that person a copy of the document. I have provided, in response to that question, a couple of links to board orders that demonstrate examples of how the public can see know what is happening, and brought paper copies that I would get you.
I'm a little worried about time,
Yes, ma'am.
just so that, and usually the first witness who lays out everything, the others don't have what is much to say after, but just.
Not in
so
this
you know.
case.
Okay, oh,
And of course, I'm already speaking so quickly, so that's
All right.
problematic too, right?
okay. Yep.
Okay.
Would you like us to skip to the part that's specific to the Public Service Board?
I think the process is a valuable thing for people to hear about, and for us to hear about what is let's go through the process.
Some of the next questions that follow, who pays for it, and how does the public know how much, we've already covered that information. The question, how many complaints have resulted in satisfactory resolution of complainants, I will tell you frankly, I don't know that, because the Public Service Board issues an order, it issues a letter, it doesn't know whether that was satisfactory to the individual. I can tell you how many, orders, or I have to leave the answer to that, I just have no way of knowing what was satisfactory to the individual. Please provide examples of responses to complaints. I have brought with me a couple orders, their responses that open the investigation.
Can we just look these up online?
And we brought
I
paper
provided
copies.
paper copies, and I will forward you an electronic version that you can post online.
Thanks.
And I also have some letters, an example of letters as well. You've asked, how is compliance with CPGs monitored and enforced? This too varies from case to case, depending on factors like project size and complexity. The Public Service Board has no field investigators or other enforcement personnel or staff. Historically, to ensure compliance, the board has had to rely heavily on self-monitoring and self-reporting by the utilities and other types of CPG holders, as well as on the Department of Public Service judgments about when the public good is served by petitioning for an investigation or other forms of compliance inquiry. Increasingly, the board also relies on site visits, post-certification filings, and public comments. The board, of course, has at its disposal the ability to send out questions, and it does so very frequently to see what the state of compliance is.
So if I might add, Julie,
Please
I
do.
want to talk about this, the compliance, what compliance filings are. You
Can you
mentioned.
hear that voice right there?
Oh, okay. I just thought maybe we could go into a little bit what a compliance filing is. We're asking ahead of time when the certificate of public good is issued for certain things to be filed with the board, documenting that certain actions have been taken. So for instance, a mitigation plan around a solar facility might be one of the things that is required. And there also could be, it's not always the case, but sometimes there is a post-construction site visit to see if those things were done. But we do rely on the public and the department and other agencies to tell us when they think violations occur.
That very nicely covers it. You've asked specifically how is compliance enforced, and the answer is through contested case proceedings. They follow on what's called an order to show cause. By whom the Public Service Board conducts the enforcement proceeding with assistance from board staff, which means, for instance, in the first instance, it might be delegated to a hearing officer to do an investigation using contested case procedures, which very loosely means developing an evidentiary record, using the rules of evidence, offering an opportunity for cross-examination.
I'm sorry, where did you say that person comes from, the investigator?
The hearing officer?
Hearing officer.
Hearing officer is a staff, is employed by the Public Service Board, and they are appointed to do these functions pursuant to statute. The board has statutory authority to delegate the kind of proceeding to a hearing officer. The final decision, though, is never made by the hearing officer. A final decision is always made by the board, having reviewed the hearing officer's proposed decision or action. Again, we've covered who pays for this as best as I'm able to. You've asked how frequently, in terms of site visits or other monitoring activities, such as issuing a data request, meaning tell us how many times you've had somebody contact you and complain or something like that. These actions occur in intervals depending on the circumstances of the case. It's important to keep in mind that CPG holders are on notice of their continuing duty to be responsive to board inquiries and to permit site visits as the board deems necessary. For what time period? Site visits typically, as Board Member Hoffman indicated, are conducted during post-certification proceedings. That tends to be the time frame following a board order. If it takes 2 years for a project to get built, post-certification will go over that 2-year period. During that time, maybe one or more site visits. But certainly for the life of the project, there's always the possibility of a site visit being conducted if it's thought to be necessary. What happens when companies don't comply? When the board becomes aware of allegations that a CPG holder is out of compliance, the board will either inquire directly of the CPG holder about these allegations or will refer the matter to the Department for Investigation. Once the response to the inquiry or referral is known, the board decides whether to take any further action, such as opening a formal investigation or issuing an order that should cause why the CPG holder should not be assessed a penalty. It's also possible that the department will investigate and the board referral and decide to petition the board for a proceeding to seek penalties for non-compliance. In addition to paying penalties and undertaking remedial action as ordered by the board, companies that do not comply with the CPG, who chronically are violating it, face revocation of the CPG. I have to say, in my experience and knowledge of the law, that very rarely has happened because compliance is generally achieved, or the CPG holder chooses to leave the jurisdiction in summer visits or something like that. You've again asked where's the burden of proof, and the answer is pretty much what I gave you before.
Yeah, a bunch of lay people wrote these questions, and we just thought, well, we'll time we'll figure it out.
I appreciate that, and I appreciate the difficulty that they faced in drafting the questions. How does the public know? Is the information posted for public access? I think I've pretty much covered that as well. It's a combination of you can certainly contact the office and ask for records that are available to the public, or you can come to our offices and ask to see the documents to the extent they're available online, which is imperfect, and we acknowledge that. You can look at them there, and we are actively transitioning to a system that is intended to make more documents available and make it easier for people to obtain information remotely from the board.
June, that answer, I think what you said, and I do have I may have a hearing problem, I'm not sure.
No, I'm sure I'm not speaking loudly enough.
Okay, I think you said we try to make the information as public.
Yes.
Yes. How do we, people say they don't know what's going on, and I guess I can't be any more specific.
Not at all.
How do they know what's public and not?
That's an excellent question. What I mean is to indicate by qualifying my answer that way is, as I'm sure you're aware, there are public records exemptions that the board is obliged to apply. And if one of those exemptions applies, for instance, if there's a confidentiality provision, or if there is personal information that is not supposed to be disclosed, that kind of things, or if it's been designated to be confidential by law. For instance, the Federal Energy Regulatory Commission has designated certain critical energy infrastructure to be confidential to prevent for security reasons. Those are the kinds of things that would lead the board to say we're very sorry, but under law we are not able to give you that information. That's what I mean.
So if I send you a request for 5 things, 3 of them are public information, but 2 are confidential, when you send it back to me, will you cite the
Yes.
state law?
Oh, yes, absolutely.
That's what, okay.
Yes, under the Public Records Act, that's exactly my obligation, is to identify the record that's being withheld and why, and to also tell you who to go to if you want to challenge that assessment, and also to direct you to the court in Washington County to bring a civil action for you to enforce your rights of access. You've asked how is the compliance documented by whom and where, what records are kept with respect to monitoring and compliance activities. I'll just look at my answer very briefly to see whether there's anything new in here. I will be providing you with a copy of these answers so they will be available for the public to look at. I think I've covered most of this question already. There's one piece where you ask, how does C complain when it is believed that compliance is not happening? How can the public initiate a compliance inquiry investigation? How does the public know that the request is acted on, resolved, or not appropriate for investigation? The best first step is for C to contact the responsible wind project owner, because there is a board-ordered sound protocol and complaint protocol in place that project owner is required to follow. The public can also contact the clerk's office directly, though, with a written complaint. The public can also contact, or C can also contact the Department of Public Service, their Consumer Affairs Public Information Division, and let them know that they think something's going on. And any one of those actions is going to trigger some level of review to make sure that it's not falling through the cracks. In all likelihood, it will be referred in the first instance to the department and to the company for response.
So of the 3 wind projects, there's a protocol for each of them. There's a protocol for each of those projects, and those are on our website. It's at one of the links that we provided for you, and are also going to be provided in
A screenshot of what's on the website. C is copied on any correspondence in order that the board issues related to complaints. And again, to the extent that we can give it to the public, if it's correspondence, if it involves personal information, I'm not aware that we have withheld anything of that nature from a public request, but it's possible I would have to look at it. But essentially, what is publicly available is given to the public. Additional questions for June Tierney? We're not there.
Well, I must tell you, when we wrote this, we had this idea that you would have separate, that the public search board had some other ways of looking at this. So if they don't, you've already answered them, or not?
I'll
I
have
think you
a
have.
real quick look at this. You've asked, are these the public service board rules? We've answered that, and we provide you links to those rules. You've asked how many complaints has the public service board received and acted on. Again, keeping in mind that the board has to make judgments about when something is a critical comment that you would call a complaint in English, and when something rises to the level of a legal complaint, meaning somebody is bringing a cause of action, is petitioning for relief, something of that nature. The Public Service Board has received approximately 40 communications, from 12 households. Those 12 households contain 18 individuals. Of those 40 communications, the result has been 4 investigations. So we have 2 open investigations right now, each one based on a sound complaint filed by one of those households I mentioned a moment ago. There was another very extensive investigation for a project in Vergennes, Vermont, and then I'm trying to think of the fourth one right now. It's escaping me. I apologize, but we'll get to the detail.
No, I was looking like this.
I'm sorry.
Okay.
So 40 complaints,
40 communications.
40 communications,
Yes.
4 investigations, 36 did not result.
I ask
an investigation.
Yes, and to be clear about that, of those 40, 22 came from one household. So, to
So
put it in perspective.
can I ask the question, is how do you make a determination that a complaint should open a docket to be investigated?
Thank you for asking that. In a nutshell, every single one of these communications is forwarded to the board for its review. That's start point. The content of the communication is looked at to see, is the individual asking for something or is the individual commenting in a critical way. When there is an indication that the person is asking for something or intending to ask for something, the first response generally is to send it to both the department and to the operator or owner of the project to get their response to the comment.
And the C would get a copy of that at that point in time. They would know that happened.
That's correct. And then when the board has the benefit of those responses, the board is then able to assess whether this rises to the level of something that needs to be investigated. Sometimes, as you will see in the two orders for the investigations that are ongoing right now, what will happen is the department's feedback will be, we think you should open an investigation. And that recommendation weighs very heavily with the Public Service Board because the department has the requisite people to go out into the field to talk directly with the owner of the project or the individuals to find out what is really going on. The Public Service Board is always a step removed from that because the Public Service Board has to be the arbitrator, the judge of these things. And so all folks who are affected by it have to have confidence that that forum for decision is neutral. So the Public Service Board always has to weigh its mind, is this something that could turn into a contested case under the Administrative Procedures Act? And for that reason, the Public Service Board is heavily reliant on the Department of Public Service to take the first cut at investigating.
Senator Collmore has a question, and then Senator Polina.
Yes, absolutely.
Attorney Tierney, you mentioned that the first best step would be for C to contact the responsible wind project.
Yes, sir.
I guess I'm a little confused why we're putting the average Vermonter in that position, and why would not the Public Service Board jump in at that point and say, hey, is this being complied with? Well, why are we doing that?
I think for the reasons I just outlined, sir. The idea is that when you own and operate a project in the state, you have an obligation to do so in a lawful manner. And so the Public Service Board orders that entity to have a process that is designed to be responsive to individuals. You don't get to do something in the state and not pay attention to the people who are affected by it. And when that process fails, then the next step is to go to the state agency, the department, or to come to the Public Service Board to make your complaint known. But the Public Service Board, as I was just saying, is a decisional body, and it is required to look at compliance matters, penalties through a contested case process, meaning the rules of evidence have to be applied. The process of cross-examination has to be observed. It's a formal process. And above all, that process has to be fair, and process has to be had within the meaning of the law. And so that to preserve that neutrality, the first instance or the first contact about complaints is had not at the board, but at the level where the folks who are on the ground are dealing with it. And then if it can't get resolved through good faith, give and take, then it gets escalated. I hope that's responsive to your question.
Senator Polina.
Actually, that was helpful because I had the same question. I thought it was rather burdensome to expect the citizen to contact the developer with a complaint, which could be rather intimidating way to go about the process and not very satisfactory. But along with that, just want to be clear that you also mentioned that the board has no field investigators or no enforcement personnel at all.
That is correct.
I presume that means that responsibility is supposed to go to the department. You also mentioned that, well, I guess I would say without field investigators, without enforcement personnel, how do you know if somebody has what you call a well-founded complaint? because early on, you said about determining if the complaint was well-founded. If you don't have anybody going out in the field, and you don't have any enforcement, you don't investigate, how do you know if it's a well-founded complaint or not?
Oh, that's why I mentioned affidavits, because it is a serious legal act to swear out an affidavit. And if an individual is willing to say, I swear that what I'm about to say is true, then the Public Service Board looks at that and says, that is a well-founded basis, a credible basis to proceed with legal action. Because you don't swear something out lightly.
But you have no way of actually knowing, you just base it on the affidavit, which is,
That's
seems
why,
like there's a piece missing there.
fair enough,
I
Senator.
wonder how many complaints you consider well-founded. I didn't know it was going on this long, so I wasn't worried about it. But I guess my last point would be, without the ability to do the field investigation and no enforcement personnel and relying on affidavits, just how do you know, how often are complaints considered well-founded, I guess is what I'm trying to say.
Let me take that in two parts. In addition to affidavits, the Public Service Board will send out queries, questions of the utility or the project owner, operator, of the department, of the stakeholders, following up asking questions. And they're reliant on the truthfulness of those answers. And then the Public Service Board will make a judgment, as it frequently is called upon in assessing facts that it receives, to determine whether there is a basis there or not. This is the agency's expertise and experience in conducting its proceedings. But I understand where you're coming from, Senator, that if you don't have boots on the ground, it does seem you're a little remote or removed from the action. And that's the trade-off, is having boots on the ground or having a decisional forum that is neutral and fair. I would offer two examples in order to put this in context, if I may. If you go to the Agency of Natural Resources, they have an enforcement division. If you go to the State's Attorney's Office, they have investigators and they have prosecutors. And so the way to think of the Public Service Board, I think here is, the Public Service Board is not necessarily an investigator, it is not necessarily a prosecutor, it is a decider. And the investigators and prosecutors, I think of as the prosecutors being the department, the investigators being the department, but I cannot sit here and represent to you that that is necessarily a shared view.
Thank you very much.
My pleasure.
I feel like that's it. You good?
Just checking to see whether we've left anything. I think that's all we have.
Thank you very much. And I can see that we're running way behind time, and as I said, usually the first witness addressing one issue, gives us a lot of information that doesn't need to be repeated, but we're going to move into our 11:30 space. Unfortunately, we have to move to another room, but Robert, come on up.
Thank you very much.
Thank you.
And I will get with the clerk to make sure that the documents are promised to you.
Thank you, and copies of your testimony in general. Thank you very much. Good morning, Robert.
Good morning. For the record, I'm Robert Justice with Green Mountain Power. I'm actually very pleased to be here this morning.
Thank you, and I just want to remind you that we're a little pressed for time. We'll be asking clarifying questions.
So I will go through my pretty quickly.
And do we have something on our iPads from you, Robert?
What you're going to have from me is a handout, which is our complaint resolution. So
If you, Chrissy, will take care of that, but if you could send it to us in electronic form when you're done, that would be great. That way you can give it all filed in one place. Thank you.
very good. So if you'll indulge me just a couple minutes, I want to give a little background. Obviously, we're coming from a slightly different perspective than the board and the department, because we are the developers. And so integral to the success of our project comes down to the level of community interactions and trust that we develop in the towns that we actually have projects built. And I do want to say, where we have projects, we have a project in Searsburg, which we've operated for about 20 years. There's 11 turbines down there. We have community wind up in Lowell. We have 21 turbines there. And then we have 3 Northern Power 100 turbines located in different places. 2 on farms, 1 on state land, and one of them was the one that was mentioned earlier in Virginia. I love talking about Kingdom because truthfully we're very proud of this project. We're proud of the project because of the amount of energy it produces. It's incredible value for our customers. We take great care and pride in how we manage it, both the facility and the grounds in which it's on. I'm particularly proud of the fact that we've conserved 2,800 acres of wildlife habitat, and that was to mitigate the 134 acres of impact that we had in building the project. As a kid, I always had this dream that I could conserve land. Well, here was the opportunity. And then finally, and most importantly, is the level of community support that we have for this project. Just a little history. Back in 2009, I and one other GMP person met with the town select board to talk about the project, just to really investigate their support, whether they were intrigued by it or not, and just to start the exploration. And in that first meeting, they said, well, if you're moving forward with this, we want the town to vote on it. To which I said, great. We welcome that, and we will respect the wishes. If the town votes yes, we'll move forward with the exploration. And it truly was an exploration. If the town votes no, we won't build it. And they were actually pretty surprised by that. And for us, but they were pleased because it was showing that we respected the community. And that's something we do with all the projects that we build. When the vote did happen, within the year at town meeting, 75% of the town voted in favor of the project. And I will say that that support has actually grown based on anecdotal comments and also a future vote in the town, which demonstrated even a higher number of people who were supportive of it.
Robert, I hate to ask you this,
Yeah.
which project are you talking about?
I'm sorry, thanks for Kingdom Community Wind. That's where I spend most of my time and energy. Kingdom Community Wind up in Lowell. That's the 21 turbines up in Lowell.
Yeah, thank you.
Yeah, the Searsburg gets no attention, and the little ones get some. But so I'm going to give you this. If you get bored of me, you can flip through the pages. And why I'm handing that out, that's a town report from Lowell. They asked the students in the school to draw pictures of the town, which they included in there. You'll see that a lot of the drawings have drawings with turbines in the background, and it really it speaks to the fact that the wind project has become a sense of pride for the community and really part of the landscape. And finally, I just want to say we conduct tours every summer. You may have been invited. You always are. Everybody is. We bring about 1,200 to 1,500 people on site every summer. And the reason we do that is so people can see, hear, and experience for themselves what a project like this looks
Robert,
like.
I'm going to have to interrupt you and bring you back to the
Yes, and that was my concluding
This is a
thing.
year's work in 2 hours.
Yes. So thank you. That was my concluding to not go into the questions. But that is an invitation to anybody who wants to see or experience or learn from themselves. So to the questions, and I'll just ask and answer them real quickly. Does your company have a written policy? Yes, we do, and I just handed that out. We do have a written, it was approved by the Public Service Board for our monitoring for sound and responding to any complaints. Do you have a separate procedure for sound as opposed to other types of complaints? No, our process for managing sound complaints is the only complaint with a specific Public Service Board approval protocol. Does your company have a single telephone number, etc., in case someone wants to get in touch with us? Yes, we do. Who does the public contact? Preston Gregory is our site manager. He actually is here in case you want to give me answered questions regarding kind of how he manages this. But he is a person who can be called day or night. Many people don't prefer to call the Department of Public Service, go that route as opposed to calling us. We've always encouraged people to call us, especially in the early years as we're learning how to manage Kingdom Community Wind. We wanted to know when there were issues that arose. So who's the person? I just answered that. It's Preston Gregory. Is it recorded? So I assume the conversation. No, we don't record the conversation, but we keep a detailed record of every single complaint. What response to the situation can be expected? When the call is received by Green Mountain Power, our response is immediate. When the complaint is directed to the Department of Public Service, then we have to wait to get that transferred to us, let us know about the complaint, and then we act upon it. I think.
Is there a preference when you
Yes,
put up a turbine in my yard?
would you say if anything happens, call?
Yes, and we actually provide the number of the person, in this case, Preston Gregory's number, not only to the town of Lowell, but all of the surrounding towns as well. We encourage people to call us. So who has the burden of proof? Our first priority is to work to resolve issues. This includes a site condition analysis during the time frame in question. So if there's a complaint, we want to know when it happened, and then we will analyze the data to see if in fact we have a sound problem. And then in all instances, we will offer the homeowner a sound monitoring at their home to determine if in fact we are exceeding our allowable limit. Does the C know what is going on? I would say yes, because we're talking with them one-on-one. And not only do they know what's going on, but in terms of when a resolution has been achieved, yes. I mean, we're actually talking with them, engaging with them, and they would know if a resolution had been achieved. Who is responsible to make all of the above happen? I mean, it's Preston Gregory as the frontline person. He receives the complaint, he gathers the data, both the operational data and the weather data, to verify if there were any anomalies that could have caused increased sound. As outlined in our protocol, we offer sound monitoring at a home to assess the sound levels. Now, we're required only to offer that monitoring if we believe the sound had exceeded 40 decibels and if the person is within 1.5 miles of the nearest turbine. We, though, offer it to anybody who has issues with the sound levels.
Do you have this in writing for us?
Yes.
Oh, excellent, thank you.
I don't have. I'll have to get it to you, because I missed that part about the writing. I thought that's
We
satisfying.
are too cool for paper on this committee.
Yeah.
Justice.
I can definitely get this.
All right.
Who pays for it? Green Mountain Power pays for it. What does it cost to implement the complaint system, including monitoring required? There was no additional cost. It's just a part of us doing business. You know, all of us participate in whatever way we're employed. We'll do whatever we need to do. Where costs come in has to do with the monitoring that we're required to do. So during the first 2 years, Green Mountain Power was required to do 2 years of monitoring. We monitored 8 times during each season of the year for 2 consecutive years. And that cost was $232,000. Included in that was $8,200, which was the cost of doing monitoring at the one home that took us up on our offer to do sound monitoring at their home. What is the company timeline for completing work on all complaints? If we have indication that there is a problem as shown by the data from our weather measurement instruments, or when we get a call from a local resident, we take immediate action. And we also, our dispatch center monitors weather and the performance of the turbines regularly and closely. And we see there's a problem, or if we get a call that's a problem, we take immediate action. And that's one of the things that we learned earlier on in the process when we first started operating the plant. I'll get to that in a second. And then I think the last question in this section is that information provided to the Public Service Board and within what time frame? Any monitoring that we undertake is required to be submitted to the Public Service Board, the Public Service Department, and the complainant. One household accepted our offer, as I said earlier, and we provided them the full report that showed we did not exceed the sound level. Important to note, subsequently they sold their home, and new people who moved in have not had any issues. Second major category of questions, how is the remedy to complainants designed, documented, and implemented? So, I wasn't sure exactly how to answer all this. I think we take every complaint seriously, and we follow the protocol in our CPG. Complaints that come through the Public Service Department, we keep them appraised of the process, the progress we've made in addressing the complaints, and they periodically ask us for information about the complaints that we've received. Most of the people to date have gone through the Public Service Board first rather than calling us. That's changed a bit as the years went on, but especially in the early years, they went through the Public Service Board, complained about it. We would learn about it when they alerted us to it, and then we would take appropriate action. We have, in terms of how does the complainant and the public know what is happening? Well, clearly the individual knows what's happening because we're communicating with them. Even if they come to the public service board, we will contact them or try to contact them. The community at large knows this because, we have good relationships with the community. We know a lot of people in the community. And we also still have a contract with 2 people who live there who kind of serve as our liaison. In addition to our site supervisor, our liaison, again, they live in the community, to either provide information to the community or get information from the community to us, including if there are any issues that we should know about. Who pays for it and how does the public know how much? As a developer and the owner of the project, Green Mountain Power pays, and all our expenses are scrutinized by our regulators. How much? Again, this is, part of doing business, so there's no particular line item that says X goes towards dealing with complaints. The only additional cost, I would say, is the folks I mentioned, the 2 people in town that we pay a stipend to kind of be our liaison, but they also help with tours.
We have a question. Just a quick question. So you said that the C goes to the Public Service Board mostly and then come to you with their concerns. And that the Department of Public Service is boots on the ground.
I would say we're the boots on the ground.
You are the boots.
Yeah, well, whenever there's a complaint, we will go.
Okay. And who else beside your organization, your company, has access to the monitoring data? Is that something that's public?
When we file the results of our monitoring, it's a public file. And copies go to, we're required to send to the Public Service Board, the Public Service Department, and the complainants. It's a public record. So however the regulators provide that access, that would be up to them.
But it is a public record.
It's public record. How many complaints have resulted in satisfaction resolution? So we had an early incident in our operation. This was during the first couple of months of operation, where we learned that sound increases if the blades are getting caked with snow and ice, right? And on the mountain, and we have cameras. Our dispatch center is very mindful and watches their output of Kingdom Wind and can tell if there are any anomalies given the wind speed and what's actually being produced. Between the weather, the monitoring, and that assessment, we know if we're at risk for seeing snow and ice build up. If we miss that, we'll get a call from people in the locale, and then we monitor that. So the resolution is that was the key issue for us in terms of sound, and we've learned now how to manage that very well. And I think what I get into next is the number of complaints that we've gotten and what the progression has been. I think it speaks to us being able to resolve a lot of the issues that have been presented. So in 2013, we had 77 complaints. Those complaints came from 12 households, and one household complained 38 times, another household 19 times, another household 8 times. The rest were obviously small numbers and just once. That was 77 in 2013. In 2014, it was down to 25, still coming from 12 households, still most of them coming from 3. And then in 2015, last year, we were down to just 6 complaints, coming from just 1 household and 1 camp. And then this year so far, we've had no complaints. And winter is a time when because of the production, that's when we get our best wind, our best production, greatest likelihood, obviously, of any kind of snow or ice buildup. That's when we had our problems and could have our problems. So this year so far, we've had no complaints. Are individuals with recurring complaints treated differently from new complainants? Residents who have recurring complaints receive more attention, right, because they're complaining, or we want to talk to them, we want to resolve issues as best we can. So I think we treat everybody fairly and evenly. Please provide examples of responses to compliments. So I thought, so you literally want email kind of things, or is this what some of the resolutions have been, what we've told people? Because what we've told people is, we'll offer to do sound monitoring at your home, so we can see if in fact we're staying below our threshold. We provide them with multiple phone numbers, which they can call anytime. And as the years have gone on, certain people have, like Preston has taken calls in the middle of the night, and we want that kind of communication. We offer to come to any home when there's a complaint, when the thing is happening, so we can experience it with them. And we've also purchased 2 properties. And then I think the last section, this seemed to be much more geared towards the department and the board. And my response to this was just, and I already talked about it, it was about how we learned in that first year how to minimize the sound as a result of snow and ice buildup, and I think we've been very successful in doing that. And that's it. So that's it.
Yeah.
I did pretty
Yes.
good.
The questions don't follow logically. So
No.
that we can go through all of them.
So I think the key takeaways are, why we've been so successful is that we have a great relationship with the community. It's a trusted relationship with the community. We respect the community. We are very responsible when we have issues, and when we can, we address them, and we address them quickly. Now, one of the things we can't do, obviously, if someone's opposed to the project on visual aspects, there's obviously nothing we can do that because they're there. But in every other instance where we can, we will do what we can to find resolution.
Senator Polina.
Maybe this is a no-brainer, your answer will be, but you say there are fewer and fewer complaints every year. I'm just wondering why. Is it because you fixed the problem? Because people moved away? Like, why do you count for the fewer complaints?
I think part of we fix the problem, because look at that first couple of months, when I was building up, they were loud. In 2012, there was a letter sent from people within the role. 27 people signed on saying they were loud, and that was at the weekend when we had the problem. So I think the large part is that we've gotten a lot better, and we've successfully. I mean, one person moved away, and then we sold their home, and then again we purchased a couple of properties. And so I think it's just running the facility well and being responsive as responsive as we can to the issues of concern, and working with individuals to try to find resolution. And it's the full gamut of what that resolution might be.
Thank you very much.
Thank you.
We look forward to having your information and this online if possible.
Yes.
Okay, good. Thank you. Department of Health, I'm not sure, is it Director Chen who's coming, or both of you? My movers take care of you here.
Thank you.
Good morning. Thank you for coming, and thank you for sending us a lot of information as you requested ahead of time. We sent you a list of questions, which people in this room have access to, but don't actually have. Thank you.
So good morning, Harry Chen, Commissioner of Health, joined here by David Englander, General Senior Legal and Policy Advisor / General Counsel. And we will provide for the committee our specific written answers and testimony shortly after. As you can see, it's being modified as we speak.
Sure.
So what I'd like to do for the committee is just provide some basic background. I'll be brief, and then address the questions as best as I can. So really what this testimony relates to is the concept of the effects of wind turbines and hail. And I understand, and I have no doubt that some people are affected by living near a wind farm in terms of their health. They may have anxiety, lose sleep, and so they lose their sense of well-being. But from the scientific point of view, with all the science to date, there's no scientific research that's been able to demonstrate that kind of direct causal and effect relationship between living near a wind turbine with the noise they emit and the physiologic health effects, meaning high blood pressure, loss of sleep, things of that sort. The health department experts continue to review any new studies, and so far we have not changed that general conclusion that is reached in the 2010 health assessment of wind turbines. But we plan to revisit and update this report this summer based on considerable new research that has come out. A special issue just this past week of the Journal of the Acoustical Society of America just came out with 4 articles on wind turbine noise and stress, annoyance, health effects, plus 2 articles on noise modeling. All the products of a very elegant, robust, and strictly scientific Health Canada study, and so we are beginning our formal review of this. We should also acknowledge the role of and discuss how we address, we prevent, and mitigate this concept of annoyance. If study results emerge that suggest the health department's 40 decibel annual or the PSB's 45 decibels hourly level should be revised to protect public health, we certainly need to examine those levels. That said, there's no doubt that stress and annoyance can affect an individual's health, but annoyance is a complex condition. Annoyance is a result of more than noise. It relates to more than just wind turbines. With wind turbines, it appears that it's also based on visual effects like flicker, flashing lights, and one's general opinion of wind turbines, whether there are safety concerns or perceived safety concerns, your underlying noise sensitivity, and how much of a change it's been before and after.
Can I back you up for just a minute, Dr. Chen? You're going to do a new report. You're going to review a bunch of new, pretty exciting literature that's going to do a new report. At the national level, we hear about what happens to reports from the time they're written to the time they're published. Does anything happen to your stuff? Like the president X's out a bunch of stuff and makes you change the information that's in there. Is there editing that happens in the work you do?
There is editing, yes. I mean, any report goes through a standard process of editing. I'd say at the conclusions, if they're scientific conclusions, there are scientific conclusions, but there are, admittedly, more different ways to say things.
The conclusions will remain the same?
Yes.
That's a question.
Yeah, scientific conclusion is a scientific conclusion.
Okay, thank you.
And I certainly would invite you to discuss. I think the last committee actually had that same line of questioning with the individual who was testifying about how I, as a commissioner, would review testimony and whether there would be significant changes based on that. And I certainly invite you to do the same. You may feel stress or annoyance if you feel you've had no input or insufficient input into a decision that affects your life, or you feel loss of control, and you've experienced a major change without a decision, without having made a decision to change. You may feel less stressed or annoyed if you actually did personally benefit, or for example, you were compensated. If the costs and the benefits of a wind turbine development are inequitably distributed, it will cause further community discord and actually increase the annoyance. And all of this compounds the other stressors that we all deal with every day. I think an important question is annoyance a public health issue? Because when it comes down to it, that's really where the only nexus connects health and wind turbine projects, and I don't really have a ready answer for that. While we can't dismiss the effects of annoyance, the WHO, the World Health Organization, has actually excluded annoyance as an outcome because of a lack of a clear definition like a syndrome or a disease. It really is a human response to a specific stimuli, not a non-specific response to a stimuli. Clearly, the health department cannot be a regulator of annoyance. But while there are ways, but importantly, there are ways to mitigate annoyance with policy decisions or approaches, compensation, a more thorough process for community input and decision-making. It's possible that we as a society might decide that a lower sound limit are warranted to prevent this annoyance. even if this decision is not really based on that direct link between noise and health effects. The health department does not have jurisdiction over the siting of energy development projects. We have advocated that public health questions and concerns be considered as part of the regulatory process. And these include greater community involvement in the siting process, including requiring developers of large-scale energy projects to conduct a health impact assessment, requiring developers to use best practices to model the potential impacts during the application process, require rigorous post-installation noise monitoring for a minimum of 3 years, require a good neighbor policy to address complaints that result from projects. With health complaints received over the past 3 years to date, the environmental health staff have communicated with 5 individuals that have had health concerns related to them and their family members, bringing to a total of 11 individuals. The communities represented included Georgia, Sheffield, Virginia, and Lowell. We have also talked to 2 healthcare providers, and in our conversations, healthcare providers have also given other reasons why individuals have had the underlying health conditions unrelated to it. In terms of our complaint process, we're standardizing our efforts in terms of our complaint process, which includes a form, an environmental health exposure incident form, and a process for communicating throughout the team when we do receive a complaint. I think it's an interesting question about trying to understand the difference between public health and population health and individual health. And how would I respond to an individual that says, I'm having all of these problems, related, and I think they're related to the wind turbine. And really the answer is, these are real problems, whether it be blood pressure or stress or not sleeping. These are problems that are best addressed and dealt with your physician. So if you have high blood pressure, then you treat high blood pressure. If you have stress, then you treat stress in one of the many ways that you can. That's really the kind of non-specific or the specific way that we really should address concerns when they're of a limited nature like this. And as much as I would like to provide an answer that would solve individuals' questions, it's not something that I can connect those dots and provide us an easy solution to. So that's really my testimony. I will provide the testimony and the answers specifically to the questions in writing. Sure.
Did you, and I apologize if I just didn't hear, did you say specifically how somebody calls the department account? Is there a hotline?
We have 24-hour number that virtually anybody can call.
Is it a phone number? Oh, right.
Yeah.
It's an online, I mean, it's listed.
It is listed, and we also have an environmental health division which actually specifically handles these questions, and that's where most of them during the day are funded. We do have, obviously, communications with the Department of Public Service in terms of our collaborative efforts when we work together on these issues.
And could anybody log on to see how many complaints you've had from Sheffield or Virginia or wherever? How is that recorded?
It's important to make a distinction between sound complaints and health complaints. When we get sound complaints, we send those folks to the Department of Public Service.
Can you all hear on this transmitter? No, we have to turn that a little bit.
Should I just say?
Yes, please.
There's a difference between health complaints and sound complaints. When the department receives sound complaints, we send those callers to the Department of Public Service to look at those questions. If there are health complaints, those would go to the environmental health staff, and those are recorded on there's a conversation with the relevant staff member. That information is recorded and stored in a form. That form is, because it has protected information, it is held confidentially. So we have numbers, but we couldn't disclose any information relative to what was on the form.
Could I jump in just? So you're not copied on the original complaint if it goes immediately to the PSB or whatever? And you're not in that email string?
Correct.
And I think, Doctor, you mentioned you'd seen 5 people or had contact with 5. Are those face-to-face contacts, or is that by phone or some other way?
By phone is the general procedure, and part of that conversation is an invitation for the individual's healthcare provider to have further conversations and discussions with us.
Thank you.
Just want to clarify, and it'd be a real question, but you mentioned the difference between health complaints and sound complaints. On the other hand, Dr. Chen, you seem to recognize certain symptoms, and that's what I would call that may relate to noise, which seems to make real possibility that noise can create certain symptoms. Does that make sense what I just said? It's okay
Yes,
if it did.
yes. So in really what I'm trying to, so some of the studies, the best studies really, at least the Health Canada studies show that if you look at a large group of people, you actually look at and measure the sound levels at each of their houses, and then you look at their self-reported health, and then you look at some objective measures of whether it be blood pressure or how well they're sleeping. And what you have to do to make that cause and effect connection is you have to say, if you have higher levels of sound, you have more likelihood that your quality of life, your satisfaction, your blood pressure is higher, your sleep is poorer. They cannot make that connection. What they can make is the connection that there are a subset of individuals with varying susceptibilities that are, it's a funny word, annoyance, because
It's not competitive.
I'd say it's community annoyance. And there are a subset of individuals, depending on, and noise comes into play, but it's more than just noise. It's whether they can see them, the turbines, whether they like them, whether they actually got paid or have some benefit from them, whether they think they're unsafe and they're worried about it. All of those things are common responses that we would all have to other transportation noise. So the answer is that they are related, but indirectly through annoyance rather than directly through the noise.
Well, annoyance is clearly hard to define medically, because you kind of know when you see it.
Right, but the reality is when you're actually taking care of people, you're still treating their blood pressure, you're still treating their stress, you're still trying to work with them in terms of their lack of sleep.
So if I said my hearing has gone down, way down, as a result of being exposed to what I think are very high decibels, would that be something of a complaint that would be related to health, or is that annoying?
Well, that's health. I mean, that's an objective. And so, in terms of actual relationship between sound levels and loss of hearing, that really requires a much higher level in terms of decibels than more like what's when we sit in new turbo dryers, right?
Right.
In the
So
Western.
complaints of fibromyalgia.
Lots of questions, Senator McCormick.
Under the umbrella of annoyance, is there any research specifically on the health effects of a sense of injustice?
Yes. Yeah. I think if you feel like it's been done to you, it's completely different than if you decide to do it. And then again, that's just a human. We're all humans. We all respond to change and stresses in different ways.
If you're being required against your will to bear
And
a
so
burden that other people are getting off the hook on.
And so to the extent that in all 75% of people approved it, 25% of people didn't approve it. And so for that 25%, there's, yes, it's a population vote, but that one person is 100% against it, right? That's either 0 or 100.
Okay, so that can jack up blood pressure?
Yeah.
Some free advice here. Thank you, Dr. Chen. When will we see the results of your study work for next summer?
I close the business, at least.
The study will be.
Oh, the study work won't be after the summer.
So it'll be online once you do it.
Okay.
Okay. Thank you very much, and you'll send us your remarks in the electronic form, and we'll also post that. Anything else? Did we forget to ask anything?
Nope. Thanks.
Thank you very
Thank
much.
you.
And thank you for all the information you've sent to us ahead of time. For those of you who haven't looked on our website, under today, there's a lot of information about work that's been done in the past few years by the Department of Health. Okay, John?
Hi there.
Good morning. Is Martha here? Martha. She's right. Oh, okay. I think we're going to be fine at 11. If we're not finished at 11:30, I'm thinking 15 minutes, 20 tops.
Sounds great.
Then we'll move for our final witness at 11:30. We'll do that in our move, so you'll have a little more time than you can imagine. John.
John Gomez, the Deputy Commissioner with the Vermont Department of Public Service.
And do we have something here from you on our iPads?
You don't, but you will. So I will follow up too. I've got a few handouts for you.
That'd be perfect.
Yes.
Thank you.
So Aaron Kosicki is here as well with me. Aaron is an attorney with our Public Advocacy Division, and he really has been our attorney who focuses most on these matters. So I've got some prepared testimony. Please interrupt me as you see fit.
Okay, well, you've been listening, so you know what
I do. Absolutely.
I want to thank you again for bringing the issue that there are processes and procedures in place.
Yes.
Mr. Copeland was some of the questions that our attention last week.
Yep.
Thank you. Go ahead.
So thank you all for the opportunity to speak with you about this today. We really appreciate your interest in this issue, and I will say the department takes it very seriously.
Did you have handouts for us?
I will, yes.
Okay.
Absolutely.
Chrissy will take care of this.
There are 3 here. So I know that you've obviously already heard from Commissioner Chen. I just want to emphasize that on issues related to public health, we at the Department of Public Service will always defer to our sibling department, the Health Department, on those issues, as is true on issues of natural resources, where we defer to the Agency of Natural Resources. But that being said, as the department, it's our responsibility and our duty to represent the public interest in proceedings before the Public Service Board. This is true in rate cases, this is true in citing cases, and this is true in investigations and enforcement issues in relation to CPGs and CPG conditions. For this reason, the department certainly has an important role in working with the board to address concerns about current facilities and their operating conditions. We also take very seriously this responsibility regarding the consideration of future CPG petitions. And on that note, I just want to, we just over the, I would say, spring, summer, and fall went through the very intensive process of updating our comprehensive energy plan. We released that plan in early 2016. Actually, there is one recommendation that I think to some degree speaks to some of the questions here today, and I just want to read that to you, just because I think it's a little bit informative. This is really sort of more looking forward than looking back, but I think it's helpful.
You want to get to the questions?
Absolutely. So, in Public Service Board, this is the recommendation. In Public Service Board proceedings related to the siting of proposed wind generation projects, the department should advocate for adoption of sound standards that are clear, readily enforceable, and protective of public health. These standards should be based on solid science, good public policy, and best practices, and would benefit from clear companion guidance regarding monitoring and compliance protocols. So that represents sort of the department's, both, I would say that represents the department's experience with current projects and how we think about how to develop these projects and the conditions relating to these projects moving forward. Now, in response to the questions we received from the committee, I want to just quickly go over a few items and share a few different documents, which I've now done with you. One important note, which is that the department for the past 2 years has retained the services of 3 experts related to noise. 2 of these 3 are acoustics experts with extensive experience with monitoring and analyzing sound levels emitted from wind turbines. The third has expertise in understanding in the nexus between exposure to sound and potential health impacts. The department retained these three experts in order to develop a better understanding of this issue, and it continues to solicit the input and services from these experts in each of the investigations that are underway at the three major commercial wind facilities that I will talk about later. I have actually, the board went ahead and did this in relation to the three projects that I think are really the focus of this conversation. The project in Sheffield, the project in Lowell, and the Georgia Mountain project. Each of those projects has what is called, I would say, sort of a noise monitoring plan and complaint protocol associated with those projects. The board has already indicated to you those are posted online, and I think the board was sharing a link for those. But what you will see is each of those outlines both the monitoring protocol that those project owners were to implement after those projects were commissioned, and then also the complaint protocol that's to be followed for each of those projects now that those projects are in operation.
That's part of the CBG, you said?
It sort of follows up as part of the CBG. They were instructed to issue those plans as part of that process. That's right. So we sort of work when it comes to how the department handles complaints. To a large degree, we are working within that complaint protocol and how we work with those who contact the department. Let me just quickly run through the documents. I guess...
You've already answered it.
Yeah. So two of the documents are tables that you have in front of you, right? And one was actually completed in late November, and one was just completed in the last day or two. The first document completed in November was an assessment of, from October 1, 2012 through November 30th, 2015, how many complaints the department has received in association with 4 different projects, and the number of individuals who have filed those complaints. I won't provide any commentary there. Happy to answer questions about that, but that just gives you some sense of scale of how many complaints we've received and from how many households. The other table, and I'm afraid I've given away all my copies, but gives you some sense of timing for those, which is for each of those projects. When when those complaints came in, right? So we just wanted you to have some sense of both how many complaints we're receiving and how many complaints over time. We thought that would be helpful context. So, as noted in the complaint protocols for each project, the complainant is directed to contact the facility owner or operator at a published phone number, right? That is what is written into the protocol. As Mr. Dostis just alluded to, that may happen. I think at least for Kingdom Community Wind, they would encourage people who feel who want to file a complaint to contact them directly. But often our experience is people contact the department directly to address these issues. At the department, they are contacting our Consumer Assistance and Public Information Office, right? CAPI. We have a team of folks who help address when a Vermonter has an issue with a regulated utility, they contact our CAPI division to address those issues. We have one particular staffer in CAPI who handles specifically the wind complaints and who addresses those at CAPI, and who has been keeping this tally of the complaints we have received over time. The general routine is, again, working within that complaint protocol. What our department staff does is then reach out to the operator of that facility, let them know that we've received a complaint. They may have also received that complaint, and then the facility operator needs to respond to that complaint. Okay? So
does the consumer know that that's what you're going to do?
Absolutely, because we then follow up with the consumer. Okay? We heard Ms. Tierney from the board testify that they also get complaints as well. And in certain instances, what you see is that those complaints have now resulted in investigations that are underway at the board. And in fact, we have, at this point, really 3 different sets of investigations going on, one at each of the different facilities. And I just want to sort of briefly describe those 3 because I think it can be helpful.
What did you call those, investigations?
Investigations, yeah.
Are you talking about PSB investigations? Are you talking about the dockets? Or are you talking about your investigation?
I'm talking about the dockets.
Okay.
We're participants in those, but ultimately those are sort of proceedings before the board. Right?
Before you talk about, well, and maybe this will address that, one of the things that we're interested in as per all these questions is how do my fellow consumers see this what we stand, we see
Yeah.
inside about it. How does see know what's going on? They call, someone said we're going to contact the operator of the unit, and then a month goes by or 6 weeks go by. How do they know?
Yeah, and ideally there is not that lag time. But I will be honest, like it is, Susan, who is the staff person in CAPI, will contact the plant operator. Often there is, in a certain amount of time, the plant operator responds. They will review the monitoring.
Is that amount
sort
of
of,
time set in the protocol?
is that, I believe it is set in the protocol.
In many of the protocols, there is a timer set out in terms of when the time frame which the operator has to investigate the complaint.
I'm sorry, you might know something like some people.
I'm sorry. Generally speaking, there's usually a time frame spelled out in the monitoring protocol to outline the time frame under which an operator has to investigate a complaint.
Thank you.
The department, on the other hand, its process is not spelled out in the monitoring protocols. So we operate sort of independently from the contours of the monitoring.
Does the department have each of the protocols that are spelled out in each of the CPGs for each of the companies? So you know exactly what the requirements are for a specific investigation?
Certainly.
Okay, and then do you adhere to the timeline that's specified within the CPG to facilitate resolution?
Again, that timeline is for the sort of facility operator.
It's for the facility operator, but as you're talking about what it is that you're doing for the complainant, can you talk about that a little bit and where you fit into the concern that an individual brings, a C brings to the operator, and then how do you get involved?
Mm-hmm.
And what's your time frame for bringing information back to C, back to Public Service Board, back to...
So the question is, how does the Public Service Department follow up and make sure it's moving? Is that a question?
Well, yeah, I mean, yeah.
All right.
So far, I haven't really gotten a clean picture of how you fit into your own process, or how you fit into the process that is specified within an individual CPG. If you could talk about those 2 things.
All right, we have a hard stop at 11:30, just to remind people, and another witness.
Yes.
Just one, the 3rd one.
And I would say the answer is a little bit different if there is an ongoing investigation into this matter, then we are participating in the proceeding before the board, right? And we are performing our own, as the sound experts I just mentioned, we're sort of performing our own analysis and working with the board to determine if there has been sort of a variance from the conditions in the CPG. Otherwise, we are really working within the complaint protocol, right? And what has happened is eventually some of those complaints have turned into investigations. And we certainly work to get back to complainants as quickly as we can. We obviously often are conveying information from the facility operator back to the person who has filed that.
Senator McCormick and then Senator Cleveland.
All the steps, all the proper protocols are means towards an end. The end being that when something is too loud, the aggrieved citizen gets satisfaction. Or if it's not too loud, then at least the operator gets vindicated. What are the end results of following these protocols? In other words, how many times has someone come to the state and said, it's too loud, and it's ended up being made to be quiet? How many times has someone gotten satisfaction as a result of these steps?
Similar to, I think you asked this question of the board, I'm not sure I can give you a precise answer to that, especially given we have pending investigations for all three of these projects, two of which clearly come out of complaints from individuals. The other that comes out of sort of, for Kingdom Community Wind, they did their monitoring that was as part of their CPG condition, their monitoring that they do, as Robert described, in the first 2 years. There was an exceedance as part of that monitoring, and as a result, there now has been a continuous monitoring program that the department is running at Kingdom Community Wind. We're 10 months into 1 year of continuous monitoring at one location, and actually are due. There is some much anticipated a report of the data that will come in association with that continuous monitoring, and we are due to issue, and this will only cover sort of the first month of that, but we are due to issue that in the coming days, actually. There's been a fair amount of impatience about the access to that data, and we are eagerly working with our sound expert to get that report finalized and distributed.
You have questions, Senator Cleveland?
Yeah, I originally had a similar question to what Senator McCormick just asked, but I'm asking another way. We were told that the Public Service Board doesn't have any enforcement personnel. So are we to assume that the Public Service Department is the one who enforces these? I want to know if somebody does something wrong, who enforces the law?
And ultimately, I would say it is, we have some enforcement responsibilities. There certainly is a capacity issue at the department. Do we have people who are explicitly enforcement personnel? No, we don't. But ultimately, we often participate. It is the board that hosts these investigations, that initiates these investigations, and then we are participating in those investigations. And we are doing that with the advice of our sound experts, who we have retained, that enable us to arrive at some independent assessment of these matters.
It just seems like the public would feel a little better if someone was responsible for actually enforcing the rules and laws. I understand you don't have the resources, but that's something that we need to deal with, because somebody needs to have the resources to enforce the rules. Sorry.
Just a quick clarification, if I could. Did I just hear you say that here we are in April, and we're going to get January's data, pretty much, in terms of the wind measurement?
When did we issue it? It's actually from
May of 2015.
May of 2015. Yeah.
It's a year's worth.
It will be that first month's data. Yeah, that's right.
I think we'd like to know more how that happens.
Yeah.
But for another conversation, could you just send us something about that, why it takes?
Just what that process, absolutely. Yeah, no, we would be happy to do that. Yeah.
Thank you.
Yeah.
Okay.
All right. So I just want to quickly summarize those three proceedings, because I think that's helpful. I already, talked about Kingdom Community Wind. There is also a proceeding underway in relation to Georgia Mountain Community Wind. Again, an individual who has filed a complaint September of 2015. An investigation is underway in relation to that complaint to determine if they are out of compliance with the conditions in that CPG. A similar narrative in relation to the Sheffield project, where there was an individual who has filed complaints, and ultimately a proceeding was initiated before the Public Service Board. In all of these proceedings, the department has pushed for and supported this opening of investigations, and we will continue to do that where appropriate. I sort of, in conclusion, want to just acknowledge that through all of these proceedings and through the engagement of these experts, the department has become much more adept at understanding what are tremendously complex issues related to sound. They really are incredibly complicated, and is really in a much stronger position to perform the advocacy role that we need to perform, and that both is in relation to existing projects, but also the potential siting of new projects here.
Thank you very much.
Yeah, thank you.
And we'll look forward to finding out what it is that takes so long. I don't know if you've noticed the sign in our committee room. It says it's complicated, but underneath it in Spanish it says, but it doesn't have to be that complicated. Thank you.
Thank you so much.
Okay, and our final witness for this room is Martha Staskas. And while she's coming up here, I know you can hear us that we're going to move. We have a hard stop at 11:30 until 11. We're going to move back to our committee room, and you and Chrissy will figure out how we get that connection for your telephone testimony again. But it will be about 15 minutes of reacting as a consumer to the process and procedure information you heard today. That's all. Okay.
What's your room?
It's room 17. You could go right through the picture of the guy sitting, would be there. It's across the ladies' room, and we'll be like sardines, just so you know. Have a seat, please.
I will. I just thought I would leave my iPhone here. It has a decibel app,
Oh, okay.
and you can watch it and see what our conversations are. It's not, it's an app on an iPhone, so it's not the high technology that we use in the field. But I thought I would give you a chance to have some sense of what 45 decibels is too.
Okay, I'll tell me what I read. So Martha, have you testified in front of a legislative committee before?
Years ago.
Okay, well you probably remember that these things are all open to the public, and we record them so that people can't come to my meeting today, can find out what's going on. So we have to say your name and where you're from before you start speaking, so people who want to listen to those CDs or whatever it is we send them will know who you're listening to. And it's recorded in perpetuity, so don't say anything you don't want you to hear. Yeah, but thanks. Well, that's just how they do it.
Well, I thank the committee for allowing me to come and join you today.
And did you receive a copy of the questions?
Yes, I did.
Okay, our focus is how someone who has been affected by wind energy production, how they complain, make complaints about their health or birds, and how we respond.
My name is Martha Staskas. I work at Vermont Environmental Research Associates in Waterbury. I've been in the wind industry for over 23 years, involved in wind energy siting, wind resource assessment, and development permitting coordination from Maine to West Virginia, and focused primarily in Vermont. I work on early stage development responsibilities and have participated with 4 of the 5 permitted projects in Vermont, being Searsburg, Deerfield Wind, Kingdom Community Wind, Georgia Mountain Wind. I also worked on a 33 wind turbine project in Coos County, New Hampshire. My responsibilities are focused on coordination and project management. I'm not a sound expert. I rely on scientists, engineers, and other experts in their individual fields. And I just want to add a personal note. For me, wind energy is all about clean air, and I just want to leave it at that, but I think there's a value there. With respect to sound, there are several peer-reviewed studies, and others have talked about and appreciate the Department of Health and their comments, and I would defer to their information. Massachusetts Department of Environmental Protection. There's also a study out of Canada, and I believe the health department will be sharing those with you.
Yeah, we'll leave that to them. We just want to look at the complete process right now.
The assessment of wind turbine sound matters is rigorous from a development perspective. It's focused, it's focused on science-based health safety. We do sound modeling before installation, and monitoring occurs after the installation, and this for the purpose of verification of the work that was done prior. We would also say that the regulatory process is protective. Vermont has some of the strictest regulatory compliance requirements. It's not out of line with the standards of other states and draws upon rural health regulations as well. And I would say that the projects are responsive. Mr. Dawson has commented on King Community Wind. I can speak to the Georgia Mountain Community Wind project. I would say that unfortunately, sometimes we even get complaints that are from neighbors that are not affected, and we respond very diligently to the complaints that are filed. Georgia Mountain Community Wind has both a sound protocol, which is similar to the Kingdom Community Wind. In response to your question to Mr. Copens, the project is required to respond within 1 to 2 business days. We typically respond much sooner than that. We, being Georgia Mountain Community Wind, has a phone number that's available. It's actually a Google Voice message, so the phone call is recorded, and then that message is emailed directly to me. We try to respond to that. However, more commonly, and I'll get to this in a minute, but we have primarily one complainant, and that complaint is typically filed through an email. So I get it there. You have maps and two pieces from two complaints that we responded to. The document that has the Duncan Saunders cover on it are our responses to the Public Service Board. Yeah, that one. And then there's another one. Both of those are how we handled the work that we went into and the response protocol and evaluation that we followed as a result of a complaint that came, in that particular case, came in. Georgia Mountain has had 4 complainants, and I draw this off of the department's table, reflecting 77 complaints. Their time period was from, I think, late 2012 through November 2015. Our project went online in December 31st of 2012. Our one complainant, well, we have, since operation, we've had one related to a non-sound issue, this road thing. We've had one complaint that came from 2.2 miles away to the south and was investigated, and we looked at data and responded to it. It was determined to be outside of influenced by the project. And the remaining 2 complaints are, I suspect, I don't have their names, but I suspect that they are neighbors to each other across the street, and one in particular. The sound monitoring process for the project and other projects that I've worked on was to take first you collect baseline data, and you put sound monitoring equipment at compass points from the project, north, south, east, and west, and you take a period of time of data collection. So you understand what it is without any new equipment or project in place. Then you model what type of turbines you think you may be utilizing. And based upon the final selection of the turbine, each turbine has its own sound profile, if you will. And so you have to be able to demonstrate to the Public Service Board that the project will be able to be operated in compliance with standards that they have set. And that are in large part based upon World Health Organization and other evaluations that they've looked at, and recommendations of experts. Then, following the installation of the project, the projects have various requirements to do operational monitoring. At Georgia Mountain, it was 1 year, and then as Mr. Doss said, it was done in 4 seasons, and to look at leaf on, leaf off. We actually yesterday, I was at the National Weather Service, and we've been looking at what the National Weather Service is calling, they call it a low-level jet. And they describe how the winds come up through the Champlain Valley and come roaring through and then go up into Canada. And so we've been seriously looking at, their wind itself makes sound and noise. And what we have found in the investigations that we've had from the complaints filed is that typically it's the wind, quite frankly. And as you're seeing in there, it sounds loud. But that's what we've been doing.
So if, so you work with Georgia Mountain Wind. Are you
I'm
considered
a consultant.
You're a consultant, but you're the person who's taking care of their complaint process?
Yes.
So I call you and I say there's a lot of noise, or there's flickers making me sick. I have the number, and somehow you got that to me. When do you call me back?
Most of the time, like I said, in our case, in the last year, maybe less, it's been primarily one complaint, and it's via email. So I try to respond as soon as I get it, or as soon as I'm aware of it, or as soon as I've had an opportunity to investigate what are the conditions of the project. But it's certainly within the 1 to 2 business days as required under the protocol.
Okay, that's
absolutely.
Okay. Business days, so if the call comes on Friday, that means you have Monday and Tuesday, you have to get everybody in.
Well,
not that you do that.
well, I'd like to respond to that because I actually did it. Just recently, I got an email at 5:30 on Friday. And it was Friday, and I was headed out for an evening. And so literally, because for an overabundance of caution, I contacted the plant operators and asked them to shut down the plant. I just didn't want to take a chance. So I do think that Georgia Mountain is being very responsive. There are other times though when we look at the operations and it's windy.
So the question is just about the process.
Yeah.
What we have in place, and if we do it. So you do that. How does you answer the person who's called, and how do they know what you're doing? That you're saying it works fine, we're not doing anything, it's windy, we're shutting it down.
I read back and say I'm looking at the data. I'll ask them, what are the conditions at your house? There is in the complaint process, in the protocol, there are some questions we ask that they provide as part of their complaint. What's the temperature? What's the direction of the wind? Things like that.
And how is it recorded? If we're looking at people enforcing their CPGs, how do we know how many phone calls you got and that were responded to in a way that's...
Yeah, our complaint is email now, so...
So you keep track of it?
I have my
somebody?
email.
You don't have to report it to
No.
not to the public service board.
Well, my email, the email is actually nowadays, for the last period of time, it goes to it's actually addressed to Dr. Chen, and I'm copied on it.
I see.
So it goes to Dr. Chen, it goes to the department, it goes to the public service board clerk, it goes to me. So everybody's aware of it immediately.
We have a couple more minutes here. And do you have any, do you record, do you have any sense of how many people are satisfied with the results of what you've done?
Well, as I said, I think we're down to one complaint. This person has contacted us before the project was even built. I was in communication with her back in November of 2012 before we even began operating. So there were complaints about the way we were constructing the plant. It's just been ongoing. So this is the location of our two primary complainants. And
The green ones.
These two, right. This one on your left is a seasonal resident. They go to Florida in the winter, and it was rented the year that we constructed the operation of the facility in 2012 to 2013. It turned out completely unknown to me, but it turned out that I know that person. And so I ended up having a conversation with her and asked her, the renter, were you aware that the project was being constructed? Were you aware of the noise or sound, or was it impacting your health or sleep? And she absolutely had no notice it at all. So it really, it was interesting to listen to Dr. Chen's comments about it. Really is a personal, seems to be a personal sort of situation.
So did they, was that person complaining? Is that what you're saying?
No, I know her.
Oh.
And she said something, she said, I live on Georgia Mountain Road and we're moving next week. And I was like, where do you live? And then it all fell together. It was just ironic, I thought. The other comment I'd like to make is that it relates to the science-based nature of this. As the department and the Department of Public Service and the Department of Health have both confirmed, there are numbers of studies out there, and I think the Department of Public Service is really doing a rigorous job in investigating the science of this situation. And I just want to read a sentence out of one of the filings that they've made. ISO 9613-2 is a regulation. It specifies an engineering method for calculating the attenuation of sound during propagation outdoors in order to predict the levels of environmental noise at a distance from a variety of sources. ISO 9613-2 is the most commonly used model for environmental noise internationally. And it's also used in terms of the sound modeling and monitoring that these projects are using in the energy projects. And then lastly, the other one I wanted to note is from another presentation that the department has been utilizing, and it is, though some variability exists among, this relates to the number of different kinds of regulations.
Right, we've got a hard stop in that.
Okay, 1 second. Though some variability exists among jurisdictions, the majority of the guidelines center around an outdoor limit between 40 and 45 dBA. This limit coincides with World Health Organization Europe noise guidance of 40 outdoors. A health-based value derived to, quote, protect the public, including the most vulnerable groups such as children, the chronically ill, the elderly, from the adverse health effects of vent noise.
Thank you very much. Now, are your remarks included in this? For example, the excerpts you made, the stories you told us, and so on. It would be wonderful if we had what you told us for the record. All you had to go back and look at the information we had before we did this.
Okay.
Thanks very much. So, committee, we are going to put that in our committee room, and we will go from there, or as they call us, Chrissy will do that. If you want to come in and listen to what she says, that's fine. She will be calling us momentarily. Okay.
Do we have anything from her?
Sure. We don't.
No, her thing today was, I figured if we didn't have, we've had other people with had direct issues with wind power, and I said we should have somebody here for sure who listens and hears it, because no one's going to believe it.
Thank you.
Good morning, Annette.
Good morning.
Senator Collmore here. How are you?
I'm fine, thank you.
Hi, we're back in our room.
Can you all hear me okay?
Yes.
They can. So just to remind you of what we talked about, you were going to listen into the testimony and then give us 10 minutes or so of your reaction to the specifics of the process and procedures and that sort of thing. We're limiting ourselves to that. And then we have a few minutes, 5 minutes maybe to ask you questions.
Very good. And can you all hear me all right?
We can, and if you have the time to send us your comments in writing, that will enhance our ability to do something with this information.
I am, at this moment, I just hit send and I just sent you my comments.
Oh, thank you. All right.
You should have them to review very soon.
Okay.
So, my name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. And I want to thank the chair and the committee for this opportunity, and I especially want to thank you for the opportunity to do this by telephone, because it was much easier for me to focus on what was being said. So I am providing you pointed comments. I want to give you a little background, and that is that yesterday marked the 7th year anniversary of my involvement in the wind issue. I was very fortunate in October of 2010 to attend an international symposium on wind turbine noise and health, where I got a crash course and learned just about everything anyone would ever want to know. And it had experts from all over the world who are working ethically to try and address the issues associated with wind turbine noise. The situation is the same all over the world. People are complaining, there are health effects, there are all kinds of problems. We are not unique. I want to start with the testimony of the Public Service Board and June Tierney, and while it was a little difficult to hear everything she said, I think that there was a component of what was said throughout all the testimony that was missing, and so that's the place I want to start, which is the sound monitoring protocols. And so the document that I presented contains the links to those protocols, and it's important to understand how they were developed. They were developed by the wind company's noise experts, and then they came through and as part of all these post-compliance, post-CPG compliance documents. So many of these wind projects come with 30 to 60 post-CPG compliance requirements. And so then interveners are given the opportunity to comment. And I recall in Lowell and confirmed with Sheffield that these things came in very much all at the same time. And so you get 2 weeks to comment. In all cases, when the public and interveners did comment, their comments were all ignored. So the protocols that are in place were developed by the wind company's noise experts and then accepted by the Public Service Board, and so they managed to set something up that is what the wind companies want. Paul Bruja in particular spent a lot of time, provided substantive comments on the plan, and let me know and confirm today that everything that he submitted was ignored.
So, and then I'm going to play you back to the issue of process and procedure.
Right, and I'm getting right to that. So
Okay.
here's what was missing.
Yeah.
What is the process outlined in these protocols? The process in all of them is slightly different, but they generally require that the wind, that the sea complains to the company, and then the company responds within 2 days, and then what happens? If there is a possible violation, then they may offer, and it's different in different protocols, they may offer testing. However, the experience has been that when C complains, the response is, we are in compliance, and therefore, that's the end of it. The experience of people who have complained, who have gotten further, is, for instance, the docket in Georgia Mountain. That was 3 years in coming, and that only came about because basically the C broke the rules and complained to the Public Service Board and the department. And in one instance, also last year, I pointed out they actually, that was good, that they should copy the board, and Martha Staskis noted, actually, no, that's not what the protocol calls for, you just complain to us. So getting it out of the wind company's hands and into the board process, there is a big disconnect there. It's not in the protocols. Now we have 3 operating projects. We have one that is in its final stages of its compliance, and I've noted on what I sent you, Deerfield Wind. I'm not aware that they have developed a noise monitoring protocol, and I'm aware that this project is intended to be starting construction soon and be in place next year. And the board was asked to hold a hearing on the noise issues because they're using bigger turbines and longer blades, and they chose not to. So we're still waiting to see when that comes along.
Which project was that, Annette?
That's Deerfield Wind's
Oh,
the
thank
Iberdrola
you.
project that received a CPG in 2009, and we have learned a whole lot more. I can guarantee you that we're going to have more people complaining if this project goes in with the noise information that was included in that CPG. So that is really our front line right now. The board had a request within the last year to hold a hearing on the noise issues, and they could have taken updated technical testimony in that, but they chose not to. So that was my first point, that the complaint doesn't lead to anything. However, in the case of, for instance, C's complaint that's before the board right now, in the Georgia Mountain Protocol, the next step, if this investigation, which took 3 years to get, actually results in anything, it will result in the offer of a test inside the C's bedroom to determine the attenuation of the house, because the complaint has to do with them being able to sleep. Now the Public Service Board standard depends on the home attenuating the noise from outside to inside. So they allowed 45 decibels averaged over an hour, and then they're assuming the house attenuates 15 decibels, so inside the house is supposed to be 30 decibels. So if C successfully gets to the next step, that next step will involve allowing the wind turbine or wind company experts to come into their bedroom to conduct a test. We have moved the point of compliance on these projects into people's bedrooms. I want you to think about that for a moment. That you would think it should be at the property line. So now we are facing the situation where C does not want the wind company's expert, who has put them in the position of not being able to sleep, to come into their home to do a test when they have no confidence in it and they feel it is extremely intrusive. But that is the next best step for C. In the case of the other investigations before the board, it took literally from 2011 until 2015 to get before the Public Service Board, and it cost hundreds of thousands of dollars. And in that case, there was one of these inside-outside tests done in July of 2014 that resulted in the Department of Public Services experts reporting 16 months later to the board. And in that case, they did find that the house doesn't attenuate 15 decibels. It attenuates more like 1, and that is a violation. And so that is now churning through the board, and the company has now gone to the board and asked to do more sound monitoring, and they want to do 4 weeks of continuous sound monitoring inside C's bedroom, including 4 weeks of continuous audio monitoring inside C's bedroom. That's the current request. In February, that request was made to the board. The board has not ruled on it. There are people who have complained, like the Terrians, who never received this response at all. The news that I heard today was that people who complain, in order to get their complaints taken seriously, the board should file an affidavit. That's nothing I've ever heard before. There was the Public Service Board did find a violation of the Lowell project, and they held a show cause hearing. It is what resulted in the continuous sound monitoring. C, who was making the complaints and who is a party to the case, spent over $200 just to participate in the board process, because it's all paperwork, and that even if you don't hire a lawyer, you still have to do all the copying and mailing. So those complaints have really not been addressed to date. I sent you a map that shows the areas that BCE documented in 2013, so this is old information, to bring some truth to the idea that there are only a few people, or 1 or 2 people complaining. We did hold a meeting in 2013 with an attorney around Lowell, and 70 people showed up, and half of them were from Lowell, and they were very angry. And I asked if they had complained, and they said, no, why bother? It's not doing anybody else any good. And then I asked them, well, what if why aren't you complaining? Well, because if I do, I'm going to be so angry anyway, and then that just raises my blood pressure, and it's just going to make me even more angry. So there is a great deal of frustration. We do not know the extent of the complaints at all. to Robert Doss's testimony, and he wasted our time giving us a public relations pitch. I'm not proud of the project. We don't know what happened when we first got involved in this. In 2012, we met with Commissioner Liz Miller and with Sarah Hoffman several times to say, you know, the idea that people have to complain to the wind company is really not okay. And they agreed to have TAPI be the vehicle for complaint. And so we really tried to work with the department to set something up. We thought at the time that the complaints that were filed according to the protocols to Georgia Mountain, to Sheffield, to Lowell would be turned over to the department. We are really not sure if that happened. So we're not really sure what the numbers are. I'm not sure if Georgia Mountains turned them over. This is, you know, I'm not sure we were helpful in doing this. But what we know is that there are people living around these projects who are not complaining, but who are suffering. There's a problem with the way the CPGs are developed because they set a limit. So, for instance, and there's difference on different projects, but for instance with Lowell, if you complain going out beyond 1.5 miles, the answer is, sorry, you're outside the distance, we don't have to respond to you. And we have had complaints going out 2.5 miles around all these projects and much further around Lowell. So even if people did follow the complaint process, they are already excluded from any further follow-up. The person that people complain to at GMP has changed numerous times. And I can understand why people just have stopped complaining there because it just has never resulted in any satisfaction. Albany's experiencing a lot of the impacts. Mr. Doss has talked a lot about the relationship to the community, but as we experience, there are a lot of people in Lowell who are unhappy too, and there are a lot of people in Albany who are suffering. The time that people call, well, if you're being awakened in the middle of the night and you're supposed to call somebody to complain, that by itself disrupts your sleep because you have to turn on a light or use a phone, and then it's hard to get back to sleep. So that the idea that you're just supposed to call and then be responded to in 2 days really doesn't help anybody get a good night's sleep. When they claim that they're being responsive to the issues that people have, that really isn't accurate. We're not aware of any fee issues being resolved to anyone's satisfaction except when they've moved away. And a lot of what we've done is backfired. When the 27 people complained, that resulted in GMP calling people sometimes 3 times to say that they needed to call them, not the PSB, according to the protocol. To Dr. Chen and the Attorney Englander, the chart that they showed was very good. However, the final steps in all the chart involved interviewing C, and this is a very important point. To my knowledge, no one has ever been interviewed except Melody McLean has talked to David Graff several times, and he's well aware of her situation. Other than that, if I go to a doctor, I want to see the doctor in person for the diagnosis. As far as I know, Dr. Chen has never actually talked to any of these people. So the system that's been set up has been set up to tell people to contact their doctors, and then their doctors are supposed to call the health department. Well, from our experience, when people talk to their doctors about the problem, they don't know anything about it, or they laugh at it or scoff at it. One doctor did call the health department to learn that, oh, we're not doing that anymore. So we don't really know what the health department is doing, and I don't understand the study that he's talking about and what they are doing, but it doesn't sound to me like they're actually going out and interviewing people and talking to them about what's actually happening. We don't know anything about a 24-hour number that people can call. There really has not been any encouragement or outreach from the Department of Health to the people, to the C people. They are all being told to go to their doctors. And we are aware of people who've been sent to the hospital by their doctors at a routine appointment. Their hearts are racing, and when they go back home, they get sick again. But when they leave home, they get better. He mentioned a cause and effect relationship, and again, that has not been investigated by the Department of Health. At the end of the Douglas administration, when the Ira Wind project came up, it turns out there are a lot of doctors who live in the Ira area. 5 of them went with us to the Department of Health, including the head of the Rutland Medical Center Sleep Center, Rutland Regional Medical Center Sleep Center, and they all had read the literature, and they were very, very concerned. And I noted that I didn't hear Dr. Chen speak at all about sleep deprivation and the health results that occur as a result of that. There was a very good study done by Dr. Michael Nissenbaum, who, by the way, now lives in Stowe, and he found increased use of medications, including antidepressants and sleep drugs, just to address the WIN project. And Dr. Chen's response almost kind of seemed to say, yeah, just give people more medication for the high blood pressure or depression, and that's really not a solution.
And then we're not gonna debate the pros and cons of the current data or old data or whatever. I just want to talk about the process and the procedure. We might be able to make a difference now.
So let's get to the Department of Public.
So we got just a couple minutes to wrap up.
The Department of Public Service has hired experts. I've included 2 links. You can read about the experts. We have no confidence in the experts they've hired. The experts are known to delay data that release that is not supportive of the wind industry, and it should not take 16 months to report out on a test where the results were known the same day. The continuous sound monitoring that they're doing has backfired totally. We expected it to be done to get regular updates to show when there was when people complained that there was something to do about it, and it's resulted in no relief whatsoever. And I've put in details here about the track record of these experts, and we supplied that to the PSD and the DPS, and so much history here that everything we've done over the last 5 years has been completely ignored. To Martha Staska, she made some statements that I think are helpful in understanding why people may stop complaining, because she referenced that it's people who are talking about it's really the wind. That is very disrespectful to the people who are complaining. And that is a characteristic that we have seen in Vermont played out by the Public Service Board, by the Department of Public Service, and the wind developers, that the people who complain are then ridiculed and made fun of, and that adds to the burden that they're experiencing. And so rather than the complaint process actually working to resolve complaints, people who stick their necks out and do complain are made fun of, and it's really not okay. I mean, this is like abusing the person first with the issue itself and then abusing them again. And the Public Service Board's Sound Standard Investigation Workshop for the neighbors was probably the most abusive public event I have ever experienced. And I went up in the middle of it and really blew up at Jeff Commons' department. And I shouldn't do that, but it was so upsetting. They canceled our presentation ahead of time. It turned it into a 3-minute program where every person had to go stand up at the microphone and speak. One of the neighbors of Georgia Mountain, who was a psychiatric nurse at the Waterbury Mental Hospital, started to talk about his experience with how they address problems, and he got cut off in 3 minutes. It was very, very upsetting how the public has been treated in all of this, and I would say that Martha Staff's presentation, and I hope you will read the notes that I've given you on it, were characteristic of what we see. And yes, this is a very personal issue. It affects people's homes, their quality of life, their ability to peacefully enjoy their home and their surroundings. They can't enjoy being outdoors, sit on their porches, and they get no relief from complaining. And I think that's a good place to stop.
Thank you, Annette. We usually post written testimony. I should have told you this. We post it on our website if you're fine with that.
Yes.
Okay, good. And thank you very much. We're going to move on and do a couple of other things, and we may take some time to process how we're going to move forward with this. But we do plan to make some strong recommendations and see how much support we can get from the rest of the Senate to do that about the process, making sure it's predictable and easy to use.
Well, right now it is very predictable.
Yeah, okay.
I think you got that.
Yeah,
okay.
all right.
Thank you very much.
Thank you, Annette. And thanks for your help setting this up. All right. Okay, Katie, we asked you to write something, and I can't remember what it was, but we're
Page 74.
Yep. So we're finished talking about this, I think. You're welcome to stay and tell some people. But I can't, what's the 74, do you remember?